On behalf of Pitcher Partners, Hall and Wilcox, and the Melbourne and Sydney Compliance Committee groups, I'm delighted to welcome you to our Compliance Forum webinar. Thank you for joining us today. We have over 300 registrations, so it's great to see that this forum is proving more popular than ever. I'm Harry New, the co-lead of HW Funds, the investment funds team at Hall and Wilcox, and I'm looking forward to moderating our webinar today. As the corporate regulators implement their strategic priorities in the current environment, there's a raft of new regulatory and compliance issues ahead for the financial services sector. Kicking off our webinar today, Elliot Stum, a partner in the HW Funds team, will highlight the current hot topics for fund managers. Elliot has deep industry knowledge and experience in the regulation of fund and investment management businesses, corporate and wealth advisors, and related service providers. He focuses on all facets of funds management and financial services compliance. Then Arena Tan, a partner in the tax team at Pitcher Partners, will take a close look at landholder duty issues for capital raisings and tax reform for Victorian commercial and industrial properties following a recent case. Arena specialises in state taxes, including duty and land tax, and advises clients on a broad range of matters across all Australian states and territories. Arena is also an Australian lawyer and a member of the Tax Institute's Victorian State Taxes Committee and the Property Council of Australia's New South Wales Tax Committee. Finally, Selena Nutley, a partner in the Hall and Wilcox investment funds and litigation teams, will explore the latest lessons for compliance professionals from the corporate regulator. Selena focuses on all aspects of commercial litigation and dispute resolution in the funds management, financial services, and real estate sectors, and in dealing with regulators. Selena assists clients with managing contentious relationships between trustees, investment managers, and investors, regulatory investigations, and disputes arising from the licensee authorised representative relationship. I'll now hand over to Elliot for our first presentation.
Thanks, Harry. So today I'm going to be talking to you about two bills that, if enacted, will reform two key areas of law that form part of the financial services laws that fund managers are required to comply with, and those are the privacy laws and the AML/CTF laws. So the first bill I'm going to be talking about is the Privacy and Other Legislation Amendment Bill, and the other is the Anti-Money Laundering Counter-Terrorism Financing Amendment Bill. Both bills were introduced last month, and in that sense, they're really fresh off the press. In terms of commencement, assuming both of these are enacted, the majority of the changes to the privacy laws will take place on the day after the bill receives royal assent, whereas for the AML/CTF changes, the key changes for current reporting entities, so people who currently have to comply with the AML/CTF laws, it's going to take effect on the 31st of March 2026. And for tranche 2 entities, which I'll touch on very briefly later, their key regulatory obligations do not apply until the 1st of July 2026. So starting now with privacy reform, the bill flows from the Privacy Act Review Report, which was released in February 2023. The report contained 89 proposals, which were directed at making legislative change. The government responded to the report and agreed to 25 proposals, agreed in principle to another 56 of them, and noted 8. It's intended that all the changes to the privacy laws occur in tranches, and the privacy bill that I'm talking about is really just enacting the first tranche of reforms. So, I mean, in summary, the privacy bill, if it's enacted, will expand the Information Commissioner's powers, facilitate the information sharing in emergency situations and flowing from eligible data breaches, and it'll require the development of a children's online privacy code. It'll provide for protections for overseas disclosures of personal information. Importantly, it's going to introduce new civil penalties. It'll also increase transparency about automated decisions which use personal information, and it's also going to introduce a statutory tort, which is intended to provide redress for serious invasions of privacy. And finally, it's going to introduce these doxing criminal offences. So, I mean, of all that stuff, the two things I really want to spend time talking through are the broader enforcement powers the Information Commissioner will have, as well as changes relating to the disclosure of automated business decisions, essentially. So if the bill's enacted, the Information Commissioner will have access to a broader range of enforcement options, as well as new functions and capabilities. These include 2 new provisions to ensure civil penalties can be tailored appropriately to the seriousness of the breach. The intention is that the changes address this gap in the current law where civil penalties can only be sought for the most egregious or serious invasions of privacy. So the bill is looking to introduce new civil penalty provisions for breaches of some specific privacy obligations and non-compliant eligible data breach statements, which can also be subject to infringement notices. So the civil penalties target specific obligations that are, the number of civil penalties, but some of them target, obligations that are really administrative in nature and, where a contravention can be easily established by the Information Commissioner. One of those things is a failure to ensure that privacy policy that an entity has adopted includes the requisite information. So that's really relevant when you're thinking about what to do with your privacy policy in the context of this new bill. The bill also will enhance enforcement protections basically available to people. And what it's going to do is, in part, expand the powers of the courts in civil penalty proceedings. It's going to empower the Information Commissioner to use general investigative and monitoring powers. It will also empower the Information Commissioner to conduct public inquiries into matters relating to privacy at the direction of the Minister. The Information Commission is also going to have enhanced code-making powers, which is going to enable it to create these codes to create greater clarity and specificity about the application of the Australian privacy principles to certain sectors. The next thing I just wanted to touch on briefly was this concept of automated decision-making. So automated decision systems are often used by businesses to assist or replace the judgment of humans in decisions that need to be made in the carrying on of its business. It's considered that the use of such systems pose privacy risks, and they can use personal information about individuals in ways that could have a significant impact on them, and there's often very little transparency around the use of that information. So what the bill's looking at doing is introducing requirements that require entities that use these forms of decision-making to include information in their privacy policies, about the kind of personal information that will be used, the types of decisions that will be made on an automated basis by computer programs, and also the use of personal information to make decisions that could be expected to significantly affect the rights or interests of individuals. The last item I just wanted to touch on is the statutory tort concept, and the bill is essentially going to provide a mechanism for individuals to have a cause of action in tort for serious invasions of privacy. It's going to provide individuals essentially with the ability to better protect themselves and seek compensation for a broad range of serious invasions of privacy. So if this bill is enacted, individuals are going to have a cause of action if they suffer an invasion of privacy through either intrusion into their seclusion or by misuse of information, when a person in their position would have had a reasonable expectation of privacy. The invasion of privacy was intentional or reckless, and the invasion of the privacy was also serious. So notwithstanding this, if there are more than one or more competing public interests that are identified in this cause of action, the plaintiff will also need to satisfy the court that the public interest in protecting their privacy actually outweighs those competing public interests, which, in terms of public interest, we're talking about things like freedom of expression and so forth. The statutory tort will also be subject to a range of defences and exemptions as well. So as I mentioned before, the privacy reform is really coming in tranches, and in terms of what could come next, only some of the things that the government responded to and has said that it agreed with or agreed in principle are actually covered by the bill. There's a number of matters that didn't make their way in, and some of the things that didn't make their way in are pretty relevant to this forum. So we've got to keep an eye out for bills in the future that can cover some of the things in the government response. Some of the items that are probably most relevant to the people listening in are the potential introduction of a direct right of action, which would permit individuals to apply to the court for relief in instances where there's been an invasion of privacy or interferences under the Privacy Act resulting from a breach. There could also be a requirement, that will amend consent requirements and require that consent of individuals be voluntary, informed, current, specific, and unambiguous. And lastly, there could also be some changes coming in about, that relate to direct marketing and targeting and trading. One thing that could be introduced is that this idea that individuals should have an unqualified right to opt out of the use of their personal information for direct marketing or trading or targeting purposes. And also that targeting of individuals should be fair and reasonable in the circumstances, and any sort of targeting based on sensitive information like health information should be prohibited. So whether reforms of that sort of kind, things not covered by the first bill, are actually progressed or implemented, it's in part going to depend on the outcome of the election and the priorities or intentions of the elected government coming in. So we don't really have too much clarity on whether any those sorts of changes will actually be introduced. So now I just wanted to move on to probably a more substantive area that we'll be talking through, which is AML-CTF reform. So as noted, this AML-CTF amendment bill was introduced last month. Key changes that are being made or proposed to be made by the bill that will apply to current reporting entities like existing fund managers are going to take effect on the 31st of March 2026. There are also some other changes around the extension of the regime, which will kick in for new reporting entities on the 1st of July of that year. So with the bill, there are basically three key objectives. So the first is to extend the AML-CTF regime to cover these tranche 2 entities. It's to modernise the regulation of virtual asset and payments technology. And one key thing, or one objective of the bill, is to really simplify and clarify the regime. So as I mentioned, one of the key elements of the bill is to expand the AML-CTF regime to what is referred to as tranche 2 entities, which are really gatekeeper type entities. So that includes things like real estate professionals, dealers in precious stones and metals, and also professional service providers like accountants, lawyers, conveyancers, and trust and company service providers. So it's always sort of been recognised that the providers of these type of services, present high risk for money laundering, exploitation, and they haven't been subject to AML-CTF regulation in Australia to date. So, I mean, obviously the coverage of lawyers will mean that, people like me will actually have to walk the walk now rather than just talk the talk, which is a little bit sad for me. It's going to make my job just a little bit harder, and I don't particularly want to be talking about this today in that context. So, apart from those key objectives, the reforms proposed by the AML-CTF bill will basically ensure that Australia meets the international standards set by the Financial Action Task Force, which is the global financial crime body. So in 2025, the task force identified some deficiencies in Australia's regime and our compliance with some of the recommendations and standards set by them. The reforms in the bill are basically going to hopefully ensure that many of the key legislative gaps in our regime are addressed, which is intended to minimise the risk of Australia effectively becoming grey listed. If we were grey listed, that would have significant economic and reputational costs for Australia. So before I talk through some of the key changes for AML-CTF, I just wanted to note that the reforms are not going to fundamentally change some of the key tenets of the AML-CTF regime. So there's still going to be requirements for businesses to enrol and in some case register with AUSTRAC. You're still going to have an AML-CTF program. You're still going to have to identify and verify your customers, undertake initial and ongoing due diligence and things like that. And you're also going to have to submit transaction and suspicious matter reports as well. But even though these fundamental concepts will not change, there are going to be a number of significant changes to some of these things in the areas covered by them, which I'm now going to step through. So the AML-CTF bill is going to really amend and alter the current approach to AML-CTF programs. The intention is that we move away from this obligation of kind of having an AML/CTF program in place and shift the focus on reporting entities to the identification, assessment, mitigation, and management of money laundering, terrorism financing, and what's referred to as proliferation financing risk in fulfilling their program development and implementation obligations. So currently, the AML/CTF law provides for 3 different types of AML programs. We've got the standard AML/CTF program, joint AML/CTF programs, and special AML/CTF programs. And also currently, the law provides for the division of an AML/CTF program into 2 parts. You've got the Part A and the Part B. Under the new regime, if the bill's passed, there's only going to be this one concept of an AML/CTF program. And that program is going to cover 2 main things. So one is this money laundering, terrorism financing risk assessment, and the other is this concept of AML/CTF policies. And these are policies that will be designed and implemented to mitigate and manage money laundering risk, and also to ensure compliance with the AML/CTF laws. I mean, in terms of the MLTF risk assessment, which is one part of the program, reporting entities are going to need to undertake an assessment that identifies and assesses the risks of money laundering, financing of terrorism, and proliferation financing that they're going to or reasonably might face in providing designated services. This assessment is going to need to be subject to review, which will need to occur if certain events occur, but in any case, it's going to need to happen at least every 3 years. The other part of an AML/CTF program under the new regime is this concept of AML/CTF policies. So these are largely going to be matters that are already covered by like a Part A, Part B of a reporting entity's AML/CTF program. There's ultimately going to be a requirement to develop and maintain policies, procedures, systems, and so forth that are intended to achieve 2 outcomes. So one outcome is to manage and mitigate risk, and the other outcome is to ensure compliance with the AML/CTF laws. So the idea that a program is broken into these 2 things doesn't mean you need separate policies or you need multiple types of AML/CTF policies or anything like that. Everything can still be housed in the one document. In terms of the MLTF risk management part of the program, these policies are going to need to cover, how you'll identify that significant changes would trigger a review of your risk assessment, how you're going to conduct customer due diligence, and how you're going to review and update your AML/CTF policies when they're required. So that's sort of that risk management outcome aspect that the program is intended to address. In terms of the internal compliance management policies, which are more geared at ensuring compliance, it's got to cover things like how the reporting entity will inform its governing body of the risks faced by it in providing designated services. It's going to have to designate an AML/CTF compliance officer. It'll have to designate, a senior manager responsible for approving changes to the AML/CTF risk assessment or AML/CTF policies. It's also going to have to cover things like how you're going to undertake due diligence on staff whose role might allow them or enable them to facilitate serious crime, or whose role is otherwise relevant to AML/CTF compliance. You're going to have to provide risk awareness and management training to staff, and it's also going to cover when you need to do that independent review of your AML/CTF program, which is a concept that's still in our current law and will be maintained. And the idea is that your risk assessment will form the basis of your AML/CTF policies. One final thing I just wanted to note is that, throughout the AML/CTF laws, you'll see these new words, proliferation financing, mentioned. So previously reference was really just made to, the facilitation of money laundering and financing of terrorism. So these words, proliferation financing, are going to be appearing quite a few places throughout the Act, and that's effectively referring to, financing the proliferation of weapons of mass destruction. So moving on now. There's going to be a few oversight and government changes, or quite a few oversight and government changes, and some of these changes are intended to effectively alleviate the burden on the governing body and shift certain responsibilities away from that person and away from that body and onto people like senior managers and the AML/CTF compliance officer. So a governing body as a general broad term, refers to people that are responsible for strategic management and oversight. The term is intended to recognise the fact that, particularly with the introduction of tranche 2 entities, that's just not going to be companies that are covered, and therefore people may not have a board of directors. So we've got this new broad term governing body that will come in. The bill also contemplates that, just in terms of one change that's going to be made is that this risk assessment and policies that I mentioned before that form part of a program, updates to them will need to be improved by a senior manager, and the governing body only needs to basically be notified of those changes. This is a shift from the current regime, which basically requires that the governing body approve certain changes to things in the AML-CTF role, AML-CTF program. So I just want to talk now a bit more about this concept of an AML-CTF compliance officer. So this is something that's always existed in the AML-CTF rules, but they're basically looking at moving this into the Act, and the idea is that this will, highlight the importance of this role. So firstly, an AML-CTF compliance officer doesn't have to be a staff member. It can be an external person that's engaged. The idea, though, is that they've got to have authority, autonomy, and independence, and be able to access information and resources to enable them to discharge their functions. So aside from that sort of requirement, they've also got to be a fit and proper person, which is this new concept that's introduced into the law. Fit and proper is really intended to have its ordinary meaning. It's not too prescribed. We don't yet know what matters a reporting entity will need to have regard to when forming a view as to whether someone's fit and proper, but the explanatory memorandum did make reference to people being able to leverage off checks and things done as part of the AFSL regime. So, we can sort of expect that those matters that will need to be had regard to include bankruptcy, criminal history, and, suspension or cancellations of licenses and things like that. Just touching then on ongoing customer due diligence, so initial and customer due diligence requirements. This is a pretty key hallmark of the AML-CTF regime. Customer due diligence essentially requires you to identify and verify your customers. The bill is looking at reframing and clarifying some of those core requirements about initial and ongoing due diligence. The requirements when it comes to initial due diligence will cover things like taking steps to establish who the customer is, whether they're politically exposed, identifying their risk, collecting information that's appropriate to that risk, and verifying that information in a way that's also appropriate to their risk. The changes are also going to require that reporting entities monitor their customers appropriately and assess, manage, and mitigate risks as they may arise over time. In terms of ongoing customer due diligence, some of the requirements that are going to be included will be things like reviewing and updating the Know Your Customer information, as well as undertaking, suspicious transaction monitoring and keeping an eye out for unusual behaviours and so forth. The bill's going to establish some parameters around when you need to apply, or when you can, apply simplified customer due diligence, or when you have to apply enhanced customer due diligence. So simplified customer due diligence is going to give reporting entities more discretion, but you can only really use them if the customer's risk is low and if other certain requirements that are prescribed are also met. You're going to need to apply enhanced customer due diligence if the customer is high risk, or if certain circumstances, or in certain specified circumstances. So in some circumstances, you're going to need to collect or verify additional information. All of that stuff is kind of consistent with the way things currently are, but as I sort of said, some of the changes are designed to clarify the way that the regime works. So the idea is that all the changes to the customer due diligence obligations, they're intended to clarify the focus around compliance with these obligations on effective risk management. So the last thing I just want to do is touch on a few other points regarding the AML-CTF bill. So this will just be the last sort of group of things that I'm going to talk to you about today. The AML-CTF bill is going to really reform this offence of tipping off, because currently, it sort of prevents a large range of information sharing, which is often done for legitimate crime prevention purposes. And it's intended to basically modernise the things to enable, businesses to do things appropriately and also make sure the focus is on harm prevention. So the new offence is going to focus on, preventing the disclosure of information where it could reasonably prejudice an investigation. Some examples of the types of circumstances that are not intended to be covered by the offence include disclosing information to law enforcement, regulatory agencies and things like that, disclosing information where it's required by law, and also disclosing information within a reporting group as well, and service providers that are helping you with AML/CTF. It also talks about things like disclosing information in the context of M&As, and disclosing information to consultants essentially engaged to help you remediate and uplift your AML/CTF processes and procedures. Another item that I wanted to talk through is this concept of a reporting group, and this is going to replace the existing concept of a designated business group. So basically, a reporting group is going to refer to a group of entities that includes, at least one, but potentially multiple reporting entities that have common risk management and compliance arrangements. So currently, designated business groups allow for the adoption of, a joint AML/CTF program, which I said earlier is going to be a thing of the past, and it also allows you to discharge, a number of limited obligations among your group, but there's no group level compliance management requirements around a designated business group. So under the reforms, this introduction of a reporting group will introduce this concept of group level compliance management. And these functions will primarily be performed by what's referred to as a lead entity in the reporting group. And the lead entity is going to have responsibility for the identification, assessment, mitigation, and management of risks across compliance for all of the reporting entities in the group. And it'll also be responsible for compliance management, basically to ensure all of those members comply with their obligations, as well as obligations under the laws, but also under the program as well. So the way all of this responsibility of the lead entity is going to be affected is by essentially deeming designated services provided by a reporting entity in the group to also have been provided by the lead entity, which is going to trigger a number of their obligations around risk assessment and things like that. It's also going to trigger a requirement for the lead entity to maintain and develop AML/CTF policies for risk management, mitigation, and compliance. So essentially, it's really about having one entity in the group that's ultimately responsible for all of the AML/CTF compliance matters relevant to the group members. And if there is a failure by one group entity to comply with an obligation, I guess it's important to note that it's not just going to be that one entity that is effectively liable for the contravention. It'll also be the lead entity that's responsible as well. So one other thing that I'll just talk about quickly on the AML/CTF bill relates to virtual assets. So the AML/CTF bill is going to change terminology in the law. It currently refers to digital currency. It's being changed to refer to virtual assets. And the corresponding definition of virtual assets is also going to be tweaked. And basically, the AML/CTF regime is going to be extended to cover additional virtual asset related services for what is referred to as virtual asset service providers. And this virtual asset service providers concept is going to replace that current concept of digital currency exchange providers. So this all kind of flows from a recommendation of the Global Task Force, where they basically said that countries need to apply regulation to the virtual asset service sector. And currently, as I mentioned, the AML/CTF Act only regulates the exchanges between virtual asset and fiat currency. So the AML/CTF bill is going to address some regulatory gaps by introducing further designated services, and also capturing within the definition of virtual assets some additional concepts like non-fungible tokens, as well as governance tokens. I'm not really an expert on that stuff, but basically the definition of virtual assets is going to be broadened to capture quite a few more things. And I mean that the intention with these changes is that basically anyone that provides virtual asset related services will need to register with AUSTRAC as a registered virtual asset service provider. So it's not just like an enrollment obligation, it's a registration obligation there as well. And just briefly, I'll just want to touch on some of the information gathering powers of AUSTRAC. So, and this is really about the broad idea of, this is really about this ability for AUSTRAC to conduct broad analysis at more of a thematic level. So the bill basically provides that, the AUSTRAC CEO is going to have the power to issue notices to obtain information and documentation in certain circumstances, and it's also going to be able to issue written notices authorising the provision of information in certain circumstances. So currently, if AUSTRAC is undertaking an analysis that requires the acquisition of data to a theme or a set of financial crime indicators, it's currently not possible under the current law for AUSTRAC to obtain higher level strategic information. So the new provisions being introduced by the bill will enable AUSTRAC to collect information from reporting entities and other people as well. That's intended to enable it to deliver its financial intelligence functions and also support cooperation and collaboration among reporting entities, law enforcement agency as well, with the intention of detecting, disrupting, and deterring money laundering, the financing of terrorism, and also other serious crime. So there's quite a bit covered by these bills, and I sort of went through it a bit quickly, but that's all I sort of had time for. So now I'm just going to want to hand things over to Irina Tan, who's a partner in the tax team at Pitcher Partners. So thank you for listening to me today.
Thank you, Elliot, for those very important updates, and good afternoon, everyone. Just in case there are some who may have missed the introduction made by Harry at the start, I am a tax partner at Pitcher Partners, and I specialize in all things state taxes, including transfer duty, landholder duty, land tax, as well as the raft of various new property taxes and ongoing developments that the state governments and state revenue officers have been and continue to be busy with, particularly in Victoria. In my presentation today, I'm going to provide an update on two key topical state tax changes. The first is on a recent and significant Court of Appeal decision relevant to capital raising and other dealings in landholders. The second one is in relation to Victoria's new commercial and industrial property tax, or CIP, which I will be referring to it as. Many of you who attended last year's Compliance Committee Forum in June would have heard a bit about it, but back then it was only just announced and there was no draft legislation yet. We now have the legislation, which has been effective since the 1st of July, and I'll briefly touch on some key aspects to do with CIP. So on the first item, that relates to landholder duty, which is something that all Australian states and territories have, albeit with differences in relation to definitions, acquisition thresholds, valuation or landholding value thresholds, liability captures, as well as relief from landholder duty. So one feature common to many states is the aggregation of interests acquired by persons if their acquisitions form, evidence, give effect to, or arise from substantially one arrangement. So this aggregation concept was looked at by the Victorian Court of Appeal recently in the case of Oliver Hume Property Funds, Broad Gully Road, and the Commissioner of State Revenue. So I've included there the full case name and the case reference as well. So broadly, the facts involve an issue of shares in a landholding company to 18 separate investors under capital raise process, which involve a widely circulated information memorandum. Worth noting is the fact that the investors were unrelated to one another and did not have knowledge of the identity or the number of other investors subscribing for shares. In that matter, each investor did not acquire a 50% or greater interest in a landholding company, and 50% there is, of course, the significant interest threshold that applies in relation to private companies that are landholders in Victoria. But in total, a 99.99% of shares were issued to those investors who responded to the IM. So what then happened was the State Revenue Office issued an assessment to the company in respect of the issue of shares on the basis that the acquisitions made by the 18 investors should be aggregated under the substantially one arrangement test. And that was despite the fact that the company had already paid full stamp duty on the acquisition of the underlying land. So worth reminding everyone here the landholder under the landholder duty rules in Victoria, the landholder and the acquirers are jointly and severally liable for landholder duty. And the SRO in this case decided to pursue the landholder company rather than each of the 18 investors that invested in the company. Moving on to the next slide, in terms of the implications of this Court of Appeal decision. Firstly, the decision is an important reminder, I think, that landholder duty rules are highly complex and can give rise to outcomes that many may not expect, including that multiple rounds of duty may be assessed in relation to the same landholdings. Secondly, for years, many in the industry have taken comfort from an SRO public ruling that contains certain examples and statements that sort of led some groups to assess or self-assess their position. And the Oliver Hume decision, or the Court of Appeal decision, and the Commissioner's position advance in that case now cast some degree of doubt over the rating of and reliance on that ruling. Thirdly, historical as well as current capital raises and other transactions related to land or land investment projects can be potentially exposed to duty. And on the second and third points, just last week, the Victorian State Revenue Office released a statement on the Oliver Hume Court of Appeal decision, and they announced a voluntary disclosure program. And broadly, what they said was that, yep, the Court of Appeal decision confirms the Commissioner's practice and treatment of acquisitions under syndicated property investments. And they decided to open up a voluntary disclosure program, stating that the Commissioner will provide a penalty tax amnesty until the 31st of March 2025, should there be voluntary disclosures of liabilities arising from capital raisings. After that time, the Commissioner states that he'll commence a compliance program and will impose penalty tax and interest at the relevant rates on any identified liabilities. In terms of other implications, while the Court of Appeal matter involved the application of the Victorian landholder duty provisions, the decision may have implications for matters involving land outside of Victoria. So as I mentioned earlier, many states have similar aggregation provisions. And lastly, the decision also highlights that property fund managers and trustees may need to consider the joint and several liability provisions for landholder duty. So where a property fund has property in a state that has got a joint and several liability duty provision, it's probably insufficient in seeking to raise capital to simply rely on, statements, say, in the tax section of an IM that says that, investors should get their own stamp duty advice. Because as I mentioned earlier, the SRO may decide to pursue the fund or the landholder instead of, or in conjunction with the investors for various reasons. So ascertaining whether there is likely to be a landholder duty liability, and then deciding commercially who is to wear the landholder duty costs, at what stage the estimated landholder duty amount is to be calculated, collected, and put aside or otherwise accounted for, and whether indemnities for landholder duty will be required are and will be important considerations. So worth also noting, I guess, the duty position of each matter will ultimately turn on the particular facts and details, and therefore it remains critical that structuring for transactions needs to be done with appropriate consideration and precision, including in relation to the transaction steps and the drafting of transaction and governance documents. Now, the second topic that I'd like to provide an update on is in relation to the new commercial and industrial property tax in Victoria, or CIP, as I mentioned earlier. So this new CIP system is a complex tax reform that Victoria has decided to roll out. And I'll touch on some key features, but it's not intended to be a deep dive. As I mentioned, it's a very complex tax reform, and even an hour session on it will not do it full justice. But broadly speaking, it's an annual property tax to eventually replace stamp duty on transactions involving qualifying commercial and industrial property in Victoria. So what you need is a transaction or event on or after the 1st of July 2024 to trigger land to enter the CIP system. So it's not the case that on 1 July, immediately all properties are brought into the system. You need a transaction or event to push property into the new system. So that will happen property by property, with each property sort of entering the system at different points in time. There is a transitional rule worth bearing in mind, under which SIP is not triggered by transactions made pursuant to an agreement or arrangement that was entered into before 1 July 2024. That middle point there has got a few sort of asterisks there because in terms of what the legislation actually says versus how it's been described and marketed to date, the actual fine print says that GD may continue to be chargeable in circumstances where land has entered the SIP system through a transaction involving a less than 100% interest in a land, and following the land's entry into the SIP system, a further transaction occurs in relation to the balance of the interest in land. So accordingly, there may be circumstances where GD continues to be chargeable, unlike some of the descriptions out there that state point blank that no more GD applies once the property is in the new system, not technically fully accurate. In terms of the rate, where properties transacted on or after the 1st of July 2024 are subject to the new rules, the annual property tax will start 10 years after the transaction date and at the rate of 1% of the unimproved value of the property. And the asterisk there is to sort of highlight the fact that that's the current rate. Of course, that's subject to potential future changes in the level of rate imposed. Moving on to the next slide, we'll look at what relevant land is in terms of what land can be subject to SIP. So it looks at land with a qualifying use, and qualifying use is linked to the Australian Valuation Property Classification Code, or AVPCC, in the ranges of 200 to 499 or 600 to 699. Where land has been allocated more than one AVPCC, land has a qualifying use if it's used solely or primarily for a use described in a code that falls in those ranges. Land also has a qualifying use if it's used solely or primarily as eligible student accommodation. Now, in terms of the payment of GD, onto the next slide, please. To smooth the transition to the new system, the government decided to provide purchasers of commercial or industrial property access to a transition loan from the Treasury Corporation of Victoria, where certain requirements are met. So the idea behind the loan is that it's an alternative to self-financing the upfront stamp duty amount for the transaction that brings the land into the SIP system. So a few key things to point out here. The loan is only available for entry transactions that involve direct property transfers, so not landholder GD acquisitions, for example. The loan, including interest, is secured by a first-ranking charge on the property. And again, it's important to read the fine print. Whilst the guidance and announcements to date refer to the transition loan as an option or choice for eligible purchasers, the actual legislation provides that there is no obligation on the Treasury Corporation to provide a transition loan, even where the requirements are met. So a few last things to point out in terms of the design features of the transition loan. Firstly, the amount of the loan is up to the full amount of GD payable, again, on the transaction that brings the GD into the new SIP system. And the loan is for 10 years from settlement date, with 10 equal annual repayments of principal and interest. And speaking of interest, that's fixed from the outset. Moving on to the next slide, we'll look at change of use GD and what that is. A property with a qualifying use that has entered the SIP system may, as you can imagine, change to a different use over time. So for example, take a commercial property that has entered the SIP system, and let's say it's transacted again, say it's on sale and the incoming purchaser enjoys a full GD exemption. If that land subsequently undergoes a change of use, say if it's redeveloped into residential apartments, change of use GD is relevant to consider. And the idea behind it is that it's intended to capture the GD that would have been payable when the property was transacted or previously transacted, to the extent that that transferee or acquirer continues to hold an interest in the property following the change of use. The amount of GD is reduced by 10% for each calendar year that has elapsed since that previous transaction. Now, moving on to the final slide, just highlighting a few key features. I won't go through everything there, but essentially the SIP, when it does kick in, it's essentially additional land tax payable by the landowner. So it does not replace land tax. It applies in addition to land tax payable. It can't be passed on to tenants under residential rental agreements or leases under the Retail Lease Act. It cannot be recovered by vendors from purchases if the sale price is less than $10 million, and that $10 million is subject to indexation each year. SIP is the first charge on land, and the SRO has very broad powers to recover SIP, including from lessees, mortgagees, or occupiers. So that brings me to the end of my presentation on key state tax updates. I'd now like to hand over to Selena to cover the latest lessons for compliance professionals. Thank you, and over to you, Selena.
Thanks, Irina, for a really interesting session. I think both of those developments have got some broad implications for the industry. So we're running a little bit short of time, so I'll talk through these as quickly as I can. My topic is, as Irina mentioned, a bit of an update about the regulator's activities. And fortunately, I suppose for me, for the purposes of this presentation, but perhaps unfortunately for some aspects of the industry, both ASIC and the Federal Court have been pretty active in the last few months. We've had some really key decisions that have been handed down, which we'll talk about today. So my topics, there's two broad topics. Firstly, we're going to do a bit of a DDO update and talk about some recent cases, and then a case that was handed down on Friday against Harvey Norman and Latitude, which deals with advertising and the effectiveness of disclaimers in advertising. So moving on to the next slide, this is a little bit of a recap about DDO. So the purpose really of DDO was to correct what was apparent shortcomings of disclosure and reduce the risk of harm caused by poor product design and distribution. DDO commenced in October 2021, so roughly 3 years in, and I think it's fair to say that there was limited guidance from ASIC at the time, and its approach so far has been regulation by enforcement, which is what makes these two cases that we're going to talk about quite influential. So yes, ASIC has issued approximately 90 interim stop orders since DDO was introduced. And initially that focused on the content of the TMDs, but the two cases that we're going to talk about deal with the next steps. So just as a little bit of a recap around what the actual obligations are, you can see the 3 boxes on the screen there. So firstly, it's to prepare a TMD, which is really aimed at defining who your target market is, how it's going to get to your target market, any distribution conditions, specifying review triggers and when those reviews must otherwise occur, and including reporting requirements. The second obligation is to take reasonable steps to make it likely for the financial product to reach the consumers in the target market. And the third is the monitoring and reviewing of whether there are any changes that are required as a result of the issuing and the distribution conduct. So it's those second and third boxes that we're going to talk about with the cases that are coming up now. So moving on to the next slide, our first case concerns FirstMac, and essentially what happened here was it's about cross-selling. So FirstMac had investors that were invested in a term deposit product, and that product was due to expire. So shortly to the maturity date, FirstMac wrote to those investors and they sent them a copy of a PDS for a mortgage-backed securities product, which was called High Lives. Obviously a very different product to a term deposit product, which had a capital guarantee. guarantee. And so along with the PDS, an application form was sent to those investors. ASIC took action against FirstMac because they said that they had not taken any reasonable steps to ensure that that effectively the target market was that the deposit holders fell within the target market. FirstMac's response was that effectively there was nothing wrong with it sending the PDS out before it did any vetting of investors to make sure they fell within the target market, because what they would do through the application and the issue process was that vetting. So they would make sure that they fell within the target market at the time of completing the application. And in fairness to FirstMac, I think when DDO was introduced, most issuers did focus on what they would do at the point of issue of the product. So the focus was on that application process. What the court found, well, effectively the court found in accordance with ASIC's allegations, and the court made it clear that the giving of a PDS was also relevant conduct, and it was a breach of the DDO to give a PDS to a retail client without first taking reasonable steps that would have resulted in, or would have been reasonably likely to have resulted in, the giving of the PDS being consistent with the TMD. So effectively, it's not acceptable to take reasonable steps concurrently with or after the giving of the PDS. So you can't do it only at the time the product is issued. You must also take reasonable steps at the time of distributing the product. What was uncovered as part of the litigation was that there was no real policy alone or in combination that would have seen any steps taken prior to the distribution of the PDS to make sure that the investors in that term deposit product were also within the target market of High Lives. So there's a few key learnings for that. The first being, if there's an investor relations team who are in direct contact with the investor base and they're talking about the variety of products might be offered, then it's very important to think carefully about whether the target markets for the products are the same across the product suite. If they are not, then there need to be extra steps taken to make sure that those investor relations teams understand the differences between the products and their likely target markets, and the steps that they ought to take to ensure they're not selling to clients who are not likely to be in the target market. So moving on to the next slide, and our second case, this is a case against Amex, and it really concerns the third of those boxes that we saw earlier, which is the existence and the triggering of review conditions. The Amex case concerned certain co-branded credit cards distributed in accordance with David Jones. So typically the cards were applied for through David Jones stores, although there was an ability to do that online, and there was a review trigger in the TMD of abnormal cancelled application rates. At a certain point, the cancellation rate of those cards was 52%, because what it turns out is people didn't understand the difference between a store card and a credit card. And so there was an alliance put together between DJs and Amex to try and work out how they could reduce those cancellation rates. But at no point in time did anyone actually think about the fact that it meant it was a review trigger under the TMD. And so the court accepted that Amex had contravened its obligations where it hadn't, where it ought reasonably to have known that the cancelled application rates was a circumstance that would reasonably suggest the TMDs for the credit cards were no longer appropriate, and that they hadn't then followed through in actually reviewing the TMDs. Amex ultimately admitted to those contraventions, so they were fined $8 million for breaching the DDO. FirstMac, we don't know about the fines yet, because that was a hearing on liability only, and so penalty will follow in the next step, and that's currently set down for December. So moving on to our next slide, as a result of those two decisions, or maybe not as a result, but after those two decisions, ASIC issued a report, and we'll skip very quickly through this, but what's important to note is this report is ASIC's observations of its enforcement activity, informal and informal. So it came up with a series of observations and then posed a series of questions around whether or not issuers and distributors were effectively complying with these, with their obligations. And these are the broad topics that you can see on the slides. Now, these slides will be distributed to everyone afterwards, so to the extent we don't go through anything, you'll be able to see these. So moving on to the next slide, what we have is here an example of some filtering questions that were used in a product that was the recipient of a stop order by ASIC. And if you have a quick look at these, you'll see that the filtering questions really reflect what is said in the TMD. And the significant issue that ASIC raised, both in its report and also when it issued this stop order, was that it doesn't think that it's appropriate that the TMD is replicated in the filtering questions. So if we move on to the next slide, you'll see that what the filtering question became after the stop order was much more simple. So it stripped out all of the detail around the aims for the income distributions and the aims for the capital growth, and just asked people what was important. And then moving on to the next slide again, you'll see another aspect of the pre-stop order and the way that these questions were framed. So it says in the first one, for instance, that the fund's target market is those intending to use the fund as a satellite application, which is defined up to 10%. And so we then go on about the different types of applications. Allocations. And then if we move to the next slide again, you'll see instead the consumer, what they're asked to do is put a percentage in there. And so then it is the issuer or the distributor's job to work out which of those allocations that it falls within. So if we move on to the next slide, we've got a bit of a summary of what we've learned from the cases, those two cases, and also the report issued by ASIC. And I think the key really is that it is the reasonable steps obligation applies right at the beginning. So it's not just at the application process, it's not that confined. And there has to be a continual monitoring and reviewing of TMDs and very prompt action when you see a review trigger. ASIC identified training as being a pillar of the expectation, so both at a board level and operational staff. And we know that these things are going to continue to come up because ASIC has said that DDO is an enforcement focus. So then if we move quickly over to our second topic, this is a case that was handed down on Friday. And essentially it's one of these things that I'm sure we've all seen advertised, and that is an interest-free package at Harvey Norman. ASIC's issue with this is that while it advertised that it was 60 months interest-free, what it didn't advertise is the only way you would get this was by applying for an ongoing credit card, which came with a monthly account keeping fee and an annual fee. So ASIC said that Harvey Norman had failed to disclose the availability conditions, and they had misrepresented the costs when they said that it would be effectively interest-free and that consumers wouldn't pay more. One of the examples given was that if someone actually spent the $1,000, which was the minimum, then they'd still result in having to pay at least $1,537 when those additional fees were factored in. So moving on to the next slide, you'll see a disclaimer that appeared in most of the ads. These ads were a combination of TV, print, and radio. And so most of them had a disclaimer which referred to fees and charges applying, and saying interest applies if you do not comply with terms and conditions. But the issue with that was, according to ASIC, that it wasn't specific enough. So it gave this perception that the fees and charges would only apply if people didn't pay within the 60 months. So moving on to the next slide, we've got a summary of Latitude's arguments. And effectively what Latitude argued was everyone knows there's no such thing as a free lunch. And in the second bullet point, you'll see they say, no reasonable consumer, skeptical of advertisements in general and knowing of advertisers' tendencies to exaggerate, would understand the offer to involve effectively a charitable free lunch. So the line from Latitude was basically people must have known that it was going to cost them something, and that there wouldn't have been so many vulnerable users because they were using responsible lending practices. So it narrowed down the scope of people who could possibly have been taken advantage of, and that focusing on less attractive aspects of advertising, which is what ASIC has alleged was par for the course when it came for advertising. Harvey Norman, in the next slide, you'll see their arguments were relatively similar, although maybe not as blunt. But they also talk about the reasonable consumer and what a reasonable consumer would expect, and that they would know that there would be extra conditions which they could seek out and obtain before acting in response to the ads. Moving on to the next slide, we'll see the court's findings. And effectively, the court didn't buy Harvey Norman or Latitude's arguments. They did accept that there were that there's some scope for the argument that consumers understand that not everything will be conveyed in an ad. But the issue that the court had was they said that consumers were being asked to enter into a fundamentally different financial arrangement than the one that was promoted. Entering into an ongoing contract for a credit card is very different than buying one isolated item. And they didn't understand, they would not have understood that there would be extra fees if they paid within the 60-month period. The issue, the court really said that this came from the prominence of the statements, the clear meaning of the statements, and the absence of any appropriate qualification to them. I know we're running a little bit behind time now, but if you can give me a couple more minutes, I'll wrap this up as quickly as I can. So if we look at the next slide about the effectiveness of disclaimers, so as I mentioned earlier, Harvey Norman did have a disclaimer. So they did say that that fees and charges would apply, but the court had a few things to say about that. So firstly, there was nothing about the alternative payment method. Secondly, some consumers may have seen the disclaimer, but they may have dismissed it because it was in such small lettering and that it may have been addressing subsidiary or unrelated matters that didn't meaningfully qualify the banner statements. Or some consumers may not have seen it at all because it was in very small lettering and it was eclipsed by the prominence of the banners. The court also said the references to fees and charges apply was uninformative and cryptic because it didn't identify what they were or how they would apply, and that the disclaimers were likely only to apply to instances of non-compliance. So moving just on to the last slide here, and that, I guess it's a question of, given what the court said, can a disclaimer still be effective? And I think the answer is yes, but context and content are all important. The more qualification is required to balance the information in a headline claim, the more prominent the qualification needs to be. And that's straight out of RG 234. What is clear, though, is some banner claims are so prominent they cannot be disclaimed. And that was the issue with that very bold 60 months interest-free. Was also an interest in an issue in the La Trobe case that some of you may be familiar with, where the name of the product differed from what was in the Constitution. And the court said, well, there's nothing you can say that's going to disclaim the impact of that. So the disclaimers really need to have sufficient prominence to effectively convey key information, and that needs to be in terms of the font size, the actual text, the colour, the placement, reference to other websites. So if you want to refer to another website or have a click through, then that's going to be problematic. And simply referring to another website or a PDS in generic terms rather than having a pointed reference to the types of fees and charges is likely to be problematic as well. So that's, I'm sorry, all we really have time for today. There's a lot more detail in the slides that you'll be sent through. But now I'll hand back to Harry to give a bit of a recap and a wrap up.
First of all, thank you very much, Elliot, Arena, and Selena for fantastic presentations. It's clear that there's a lot happening on the compliance front for fund managers to be on top of. So please let us know if you need any help. That brings our session to a close today. I'm afraid we've run out of time for questions, but we will get back to those of you who have submitted questions. Also, as Selena said, we'll provide links to the presentation and a recording of our webinar in the next few days. So on behalf of Pitcher Partners, Hall & Wilcox, and the Melbourne and Sydney Compliance Committee groups, thank you again for joining our webinar today. We hope you found the session interesting and informative, and we look forward to seeing you next time. Thank you.